Hello, hello, everyone. We are starting and kicking off our Lunch and Learn in January with Evan. I will do a formal introduction. Um, just wanted to see how many we have on. I think we can start. We do have a full agenda, so welcome everyone. Thanks for joining our Lunch and Learn this month. For those who are not familiar with me, my name is Maya. I am the Senior HR Consultant with H2R and your host for today. As you can see, you have been muted, but we do encourage you to ask questions throughout this webinar. And then please use the comment section or the Q&A box to type your questions in. As I mentioned, today we're diving into labor and employment year in review with Evan Campbell and Ryan Perry, associates at Fillion Wakely. I'm very excited for this legal review and to learn what's coming up for 2026. So take it away, Evan and Ryan.
Thanks, Maya. Good afternoon, everyone. Pleasure to be here. And so as mentioned, the plan today is to do a bit of a review, looking back at 2025, and then also touch briefly on a little bit of a crystal ball. What can we expect and what do we think is going to happen in 2026? And we're going to start by going back and looking at the changes to the legislation. And as many of you are aware and who attended some of our other presentations, there's actually a lot of developments in 2025 in terms of modifications to the Employment Standards Act. So a great time at the start of 2026 to go back, make sure we're aligned on those changes and have proactively addressed some of the developments. We'll get into some case law that Ryan will touch on, and lastly, we'll turn our minds to 2026. As Maya mentioned, we welcome questions, welcome comments. There's a Q&A box. I'll do my best to monitor. I know Maya's monitoring as well, and we will do our best to answer throughout, but also we're going to aim to save about 10 minutes at the end to also dive in any questions that we receive. So let's turn to the legislative changes. And so we saw some big developments in the Employment Standards Act. So Spencer, if you can go to the next slide. And it seemed in 2025 that the Ontario government was constantly introducing new pieces of legislation to keep all of us on our toes. Some of them, I think, had more substantive impact on employers than others. But we're going to highlight a number of the changes. And so starting with the long-term illness leave, which I do think has some substantive impact and important for us to talk about for a few moments. And so this is a new 27-week unpaid leave, which the employee is entitled to if they are suffering from a serious medical condition. And the employee must have worked for 13 consecutive weeks prior to triggering entitlement to the leave. But it does become relevant when we look at some of the protections that flow under the leave. And so let's go to the next slide, Spencer. And so in terms of eligibility, the employee must provide a note, but that note really must just indicate that the individual suffers from a serious medical condition. What that is in terms of how we define serious medical condition, we don't have much guidance on in terms of the legislation. So really, as long as the doctor, RN, other practitioners specify the individual suffering from a quote unquote serious medical condition, then it's going to trigger entitlement under this leave. And as mentioned, it's for 27 weeks within a 52-week period. Few important points I would flag for this leave that have come up in the last little bit with my clients is firstly, always good to remember that under the Employment Standards Act, even though it's an unpaid leave, the individual has certain statutory rights. One of them being that all benefits must continue for the statutory period. No different than other leaves such as maternity leave, for example. So that's number one, all benefits must continue during that statutory period. This becomes relevant, and I've seen this arise in other scenarios where we have an individual, for example, who's going off on long-term leaves, and the employer has a policy which speaks to benefits ending when someone's not at work for a certain period. So often we see, if an individual not actively at work for 12 months, their group health benefits would cease, for example. So that can be defensible, but we got to be careful now with this new leave that the person is not on one of these statutory protected leaves, because if we end benefits, then we'd be in violation of the Employment Standards Act. So a nuance there that we need to be a little careful of. Number two, I would say important for us to be mindful of is our existing policies around long-term leaves, around accommodation. We should have policies addressing those points, but a good reminder for our business leaders, HR teams, that now there's this other leave under the Employment Standards Act, which an individual could be eligible to be on if they're suffering from a serious medical condition. And then lastly, I would remind everyone that this is only addressing your obligations under the Employment Standards Act. We, of course, have human rights legislation, which imposes obligations on employers to accommodate employees who are suffering from serious medical conditions. So even though this person may be on 27-week leave, if their condition continues past that, you're not in a position as the employer to say, sorry, you have to come back to work or your employment ends. Of course, we have this obligation to accommodate, which may require a much longer leave. And that, of course, interjects with disability management in terms of any disability coverage that you provide employees. So an employee may be on this leave, simultaneously may be applying for a short-term disability, may or may not go on long-term disability. So we have these various obligations, both under the Employment Standards Act, but also human rights and also our own policies and procedures as they relate to disability coverage. So just a new leave, important for us to be mindful of. Another important change that happened on the next slide deals with information that we're required to give employees. And so this came into place July 1st of 2025, and now employers are required to provide new hires the information listed on the slides. So again, this is one of those easy kind of check the box compliance requirements, but you just want to make sure you're doing it, right? Nothing in here is onerous by any means. And really, in my view, it's just a matter of checking your offer letters, making sure they provide this information, and probably making some minor tweaks just to update them to make sure you're specifying the pay period, for example, the payday, some of those things which we may have omitted in the past. Now important to make sure that they're in your offer letter. So takeaway on this piece really is just do a compliance check your offer letters or any other documents you're providing employees at the outset of employment. Make sure it captures the various pieces. I will say that this only applies to employers who have 25 or more employees. But I would say, again, not onerous. So a good action item, even if you're hovering at or below that number, to still provide this information to the prospective and new hires. So we have new information. The other big piece was some more leaves on the next slide that came into place near the end of 2025. So firstly, we have a new job seeking leave, and this only applies where there is a mass termination. And so, as many of you are likely aware, if an employer terminates 50 or more employees within a 4-week period, that triggers certain provisions under the Employment Standards Act dealing with what we call mass terminations. And there's certain additional legal entitlements that the employee is eligible for in terms of payment and notice. And now, in addition to that, those individuals who fall within that unfortunate bucket are also entitled to 3 days unpaid off during that period to engage in activities relating to obtaining new employment. So again, if you're in that situation where you're engaging in that mass termination, another piece we're going to have to reference in our letters, make sure that we have our leadership aware that yes, they have to be granting time off for individuals to be looking for new positions. Along that same vein, we also have extended layoffs that were introduced. And we kind of see the introduction of these measures end of last year, I think in response to some of the economic uncertainty flowing from Trump and the tariffs and some of the business realities that are many people are concerned of. So we had this new leave for people looking for a job in mass termination. We also had extended layoffs introduced to provide businesses another tool to keep employees while putting them on layoff. And so generally, layoffs, as many of you are aware, 13 weeks or 35 weeks up to 52 weeks, um, where we're continuing substantial payments, benefits, et cetera, during that period. With this modification, or I should say, the introduction of a new leave, that period was extended. Key piece, though, is that it can only be extended where the employer has received approval from the director of employment standards. So that's a big piece of that puzzle. So again, if you're in that unfortunate situation of we're going through some business challenges, there's a light at the end of the tunnel. We want to carry our employees, staff to that end. We want to place them on a layoff, but we need a longer period than the current time frame. Again, this is a tool in the toolkit, and I would say it can be helpful. Key piece, got to get that approval in advance. So, of course, work with your HR team to make sure that you're going through those appropriate steps. Other piece I would flag for everyone, just as a reminder, is that there were administrative penalty schemes introduced under the Occupational Health and Safety Act and the Workplace Safety Insurance Act. What that means practically is now the Ministry of Labor, when they come visit your place of work, historically they would, if they weren't happy with something, would issue a notice of compliance, and you'd have to comply and comply with the order essentially from the Ministry of Labor. If you didn't, you'd get charges, it'd be prosecution, and then potentially a fine. With this new scheme, the Ministry of Labor officials can actually issue fines based on their own inspections and investigations. So it's essentially giving them more power and authority to impose penalties for non-compliance. And I know many of you on this call, if not all of you, are focused on the health and safety and ensuring compliance and working with whether it's internal or the H2R team, but a really good reminder beyond the potential of prosecution, just this issue of immediate fines being imposed. From a WSIB perspective, there is the potential for fines if we essentially provide incorrect information to WSIB. There's some risk there. Not that those fines would flow from us making a mistake, for example, but if we intentionally mislead WSIB in terms of injuries, return to work, any of those details, that's going to result in exposure for potential fines. So again, just reminders of those obligations and making sure that we're not only meeting, but exceeding what we have to do from a health and safety perspective. All right, let's go on to some job posting requirements. This received, I think, a lot of news buzz at the beginning of this year. And I'm sure we all heard or saw some of the articles and interviews. But essentially, as of Jan 1, 2026, again, for employers with 25 or more employees, we have certain obligations with respect to job postings. And so, of course, this applies to publicly advertised postings. So your internal postings, the general help sign, for example, not going to apply, but the vast majority of recruitment efforts that organizations are engaged in today's world, Indeed, LinkedIn, etc., this will apply. Let's go to the next slide, Spencer. And so now we have the salary transparency obligation, which again got the most, I would say, buzz and lots of questions flowing to us around this issue. Some concern by business owners and professionals around what information they have to disclose. One of the common questions that we received was around, well, what do we mean by compensation, right? Because of course employees have base salary, base pay, but many employees have commissions, have bonuses, have option plans, you name it, right? To make up that kind of notion of compensation. And so when we talk about this issue of, well, what do we mean by compensation? The regulation talks about wages and that definition of wages under the Employment Standards Act, which is a broad definition. And that definition does capture your commission payments, does capture, of course, your salary, does capture non-discretionary bonuses. So a good reminder that when we think about compensation and what we have to disclose in our job postings are not necessarily limited just to base salary. There can be other components of that compensation scheme that we may have to reference. And there's, of course, can be some difficulty there. And I'm sure in the audience you're saying, well, how do we know what the commission is going to be when a salesperson, or how do we know what the bonus is going to be when it's, you know, potentially a discretionary bonus? And I always go back to base principles. The focus of this legislation is transparency. And so we can provide some level of transparency around the commissions, around the bonuses, or we most definitely should be able to. And so that may look like, base salary 100,000, commissions starting at 10,000 with room up to this, bonus of 20% of base, up to this, for example. So there's ways that we can craft it that, from our perspective, achieves the goal of compliance, transparency, but also not overcommitting in terms of that job posting. So I think that's some nuance there, which I think all of us need to think through about how we provide transparency, but also not overpromise in terms of what that comp is going to look like. Other pieces on the job postings, of course, we have AI. We got to make sure if we're using that, we're disclosing that. We have to be clear whether a posting's for an existing vacancy. And on the next slide, there's also some further requirements in terms of the recruitment process. So when we finish our interviews, we have to advise within 45 days of the applicant's last interview about what's happening. And then on the last bullet here, we have an obligation to retain the job posting. So on that first point, looping back and advising the outcome, again, I think a lot of businesses already do that. I don't think that's a big ask. The second piece, though, I think does deserve some attention, right? So a good reminder around what is our document retention obligations generally as an organization? Are we meeting those? What does our policy say about document retention? Because again, the Employment Standards Act has a host of obligations of documents employers are supposed to retain. So does health and safety and other legislation. Obviously, Income Tax Act has various obligations. And so it's a good idea. If you don't have one, I would suggest having some type of policy or procedure which very clearly outlines what documents we're retaining and for how long. Because again, something like a job posting, if we don't have that clarity, it's very easy for someone who's maybe pulling down that posting just to throw it away, never use it again, right? Or repurpose it so we don't actually keep what was posted. So again, a good reminder to make sure we're achieving that compliance piece, because where that rubber hits the road is in litigation, meaning we're litigating with an employee and their lawyer says, well, hey, the Employment Standards Act says you have to retain all this stuff. Give it to us all. And then when we fail to disclose or we can't produce, now we're in non-compliance with the Employment Standards Act. Now they're asserting regulatory violations, and it just can create an unneeded issue versus us just having those documents. So again, now we have this requirement. I would say go back, touch up your document retention policy, make sure you have this noted as an important item. A couple more items before I pass it off to the case law. Let's go to the next slide. We have a new leave yet to be implemented in terms of the date, but it will be a 16-week unpaid statutory leave, and has to do with, as you see on the slide there, the placement of a child into an employee's custody, the purpose of adoption. So again, just another leave I have to be mindful of in terms of when these scenarios arise, make sure we're advising employees appropriately of their statutory rights. On the next slide, wanted to touch on briefly the Digital Platform Workers Act. And interesting piece of legislation which applies, of course, as you can guess, to the digital platform. And it's really an attempt by the government to extend the protections of the Employment Standards Act to not only employees, but also independent contractors who are engaging in the use of these different platforms, which is a little nuanced there. Historically, organizations have attempted to use independent contractors to really sidestep application of employment standards. This piece is really bringing them back into the fold and saying, hey, if you're doing Uber on the weekend, you're going to be captured by this. You're going to have all these entitlements under the Employment Standards Act. So to the extent you may fall within this digital kind of platform as an organization, even if you're using contractors, a good flag that you got to be mindful of what it says about the Employment Standards Act in terms of potential entitlements and liability, and make sure you're in compliance. Obviously, the biggest is be at least paid minimum wage, right? Which you hopefully is the individual's making, but in some of those scenarios, depending on workflow, there could be times where they're not, right? So really have to think through, is there potential exposure and liability based on this new piece of legislation? So that's a whirlwind of 2025 in terms of legislation. Lots of changes. I think some of them more substantive, which I've tried to flag, and I think some nuance flowing there in terms of some of the policy changes, et cetera, that you need to be mindful of. We're now going to pivot and we're going to spend about 25 minutes-ish with Ryan touching on some of the cases. Again, there's hundreds of cases, as you can imagine, in 2025. We wanted to pick a couple which we thought were appropriate and applicable to all of you, just to flag a couple issues. So I'll turn it over to Ryan.
Thanks, Evan. Good afternoon, everyone. As Evan mentioned, I'm going to discuss some notable case law developments, which are also worth paying attention to in addition to the legislative developments. What we saw last year was a lot of development around one particular issue, which we're going to spend some time on today, which is the case law surrounding termination provisions. So if you can go to the next slide, please, Spencer. And the next slide as well. Okay, so first I wanted to provide an overview, which may be a review for many, of why these termination provisions are so important. As we know, the Employment Standards Act sets out an employee's minimum entitlements on termination. And typically what these termination provisions are designed to do are to limit the employee's termination entitlements to those minimums under the Employment Standards Act or some other contractual amount under the employment agreement. And this is largely because common law notice provides for a far greater amount upon termination than you would see under the Employment Standards Act, or frequently that the parties would contract for. And on that point, common law notice is like a general rule of thumb is that it's 1 month per year of service, but that's not a real rule of thumb. It's varies a lot depending on certain factors that is specific to each individual employee, such as their age, character of employment, length of service. So that these factors can all serve to either extend or reduce that common law notice period, but the point being that it's often far greater than the minimum standards under the Employment Standards Act, which is more typically 1 week per year of service. And as we know, the ESA also contains many other minimum terms of employment that an employer can't contract out of. For example, those sections relating to things like job protected leaves. And I'm flagging that because if a termination provision attempts to contract out of the Employment Standards Act in any way, a court may find the provision invalid and award common law notice. And as we'll see in the next few slides, the courts have set a very high bar for upholding these termination provisions. And there have been several notable developments this year that are worth paying attention to. And the first case that we'll discuss today is Birch v. Data Stealth. And this was a decision that was recently upheld by the Ontario Court of Appeal, upholding the enforceability of a termination provision limiting to the ESA minimums. They found that in this case, the provision stated that an employee who's terminated with or without cause will receive minimum entitlements under the ESA, and that a reasonable interpretation of that provision shows that not depart from the minimum standards guaranteed by the ESA. And in a second, we'll flip to a slide showing exactly the language of that termination provision. But just as some background on this case, the facts were that this case involved a vice president who had 8.5 months tenure and a $300,000 salary, and he was terminated without cause. The employee was given 4 weeks pay in lieu of notice and was only allowed 1 week under the ESA. The plaintiff sued for common law wrongful dismissal, arguing that this termination clause in the contract was void and that he should get common law reasonable notice. And the employer brought a motion seeking the court's interpretation of the provision, leading to the court agreeing that the termination clause was clear and enforceable, and that there was no reasonable interpretation that it violated the minimum entitlements under the Employment Standards Act. And this was upheld by the Ontario Court of Appeal. And so this is an important development for employers, given that there's such a high bar, that we now have a good example of something that the courts are viewing as enforceable, to sort of look to as sort of the standard for what's acceptable in the current moment. And if you flip to the next slide, please, Spencer. So this is the exact termination language. I won't read it all out, but we've reproduced it here so you can get an idea. And I think a key part of this is that first sentence where it says, if your employment is terminated, you'll be provided with only the minimum payments and entitlements, and then in the next comma, if any, owed to you under the ESA and its regulations. And then in the last sentence of that first paragraph, it says, you understand and agree that in accordance with the ESA, there are circumstances in which you would have no entitlement to notice of termination pay, etc. And so what this is doing is putting the employee on notice that basically, unless otherwise required, they're going to be getting the minimum standards under the ESA. And when it says, if any, it's meaning that there are certain circumstances under the ESA, which is if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and not condoned. That's the only circumstance, if we can meet that bar, that they're not going to get ESA. So that's why they're so careful in this provision about drafting it in that way. And in this case, it was rewarded by the court, and they said that that was a proper way to draft that. Now we'll look at a few cases where it was less successful and what that means for us moving forward. So Spencer, if you can flip to the next slide, please. So turning to look at some contracts containing a specific term at any time. There were a lot of developments over this past year regarding the use of this phrase. And it's a very common phrase that you'll see in a lot of pre-existing employment agreements. They often state that an employer can terminate at any time or in their sole discretion. And in February of 2024, there was a decision called Dufo versus Ignace, which found, the motion judge in that case found that the termination provision was invalid for, among other reasons, that it allowed the employer to terminate in their sole discretion and at any time. And the reason for this was the judge in Dufo stated that, or he reasoned that there were times when an employer couldn't terminate in their sole discretion, and there were times where it wasn't necessarily true that they could terminate at that particular time. And an example is, again, on those job protected leaves where an employer's rights are sort of restricted. That decision in Dufo was appealed to the Ontario Court of Appeal, and the Ontario Court of Appeal expressly refused to decide on the issue of the at any time language, was causing a big stir in the employment law community. And they decided it on other basis that's not really relevant to the purposes of what we're talking about here today. But suffice to say that it sort of left it open in 2025. If we have the phrase at any time in our contracts, is it enforceable? Is it not? And then in 2025, we see one example is Chan versus NYX Capital Corp. And we've reproduced the language on the screen there, which does include that language at any time for any reason at its discretion. And in Chan, the court followed the reasoning, the motion judge's reasoning from Dufo, and held that the termination provision was invalid for including those terms which we've highlighted on the screen there at any time and for any reason. And the court just, again, reiterated the reasoning that there were certain times where an employer doesn't have the absolute right to dismiss an employee. And in this case, there was an example included, for example, like an employer cannot terminate in reprisal for an employee exercising rights under the ESA or like a related act. So therefore, the inclusion of at any time for any reason had the potential to violate the ESA in those circumstances. And the termination provision was invalid as a result. So turning to the next slide. So yet another case where we see a provision being struck down for including at any time language. This case is from February 11th, 2025, and the court in Baker v. Van Dolders. We've reproduced the language that was at issue in that case. And what's reproduced on the screen is a fairly standard provision that you'd often see in contracts predating these cases. And the court in Baker simply stated that it was following the decision in Dufault, that it didn't have a reason for departing, and held that the decision was unenforceable. Which sort of gave some momentum to this idea that if you include at any time language in the contract, it's going to invalidate your termination provisions. And just as an additional note here, and aside from the at any time point, the court also took issue in this case with the inclusion of the phrase just cause. And we sort of touched on it earlier, and it's a bit of a nuanced discussion, but it's enough to say that the just cause standard is different than the willful misconduct standard under the ESA. If just cause at common law is established, but not conduct rising to the level of what the ESA has defined as willful misconduct, an employee is still going to be entitled to their termination notice or pay in lieu as described under the ESA. And the court in this decision held that an employee cannot be expected to know the difference between those differing standards, as again, it's quite a detailed, nuanced conversation. So turning to the next slide. So what I've just gone over with those past two cases is looking a little bleak for employers, but then we have this decision in Jones v. Stride, Toronto, which provides a glimmer of hope for us and something to hold on to. And this decision was released in April 23rd, 2025. And the court found in this case that at any time language was enforceable, reasoning in part that the words at any time, when divorced from the phrase that commonly accompanies it in sole discretion, just including at any time was not improper in an employment contract. So the takeaway from Jones v. Strides is that the court upheld the use of the phrase at any time and stated effectively that by itself, without other things that are potentially a violation of the ESA, it's not enough to render the clause unenforceable. However, the asterisk you see on the slide is because the court in this case did find the termination provision unenforceable on other grounds, which obviously, while this helps us in terms of the at any time language, it would have been nice to see it in the case of a fully enforceable termination provision like we saw in Birch v. Data Stealth. So turning to the next slide. And we have another decision upholding a termination provision in 2025, which included the phrase at any time. And the plaintiff's counsel in Lee versus Wayfair cited Dufault and Baker, those decisions in arguing that the provision must be struck down for including the phrase at any time. But the court disagreed in this case, noting that the wording was different and should therefore lead to a different conclusion. And this case in Lee helps to reinforce that there is a foothold for arguing that at any time language in a contract doesn't necessarily mean that that provision is unenforceable if everything else is in line and if we don't have that sole discretion. And here you can see that they're very much, defining cause according to the ESA. They're adding like certain caveats unless otherwise required by the ESA. So aside from the use of at any time, this is an enforceable provision, and the court fortunately did not overturn that just because of this, the inclusion of those three words at any time. But with that said, it's still somewhat of an open question. And the best course for now is likely to, review contracts. If it does include this at any time language, it may be worth looking at for removal, just because it's such a hot button issue at the moment, and there are cases going both ways. Or if it is going to be included, or if it is included, to review to ensure that there's nothing else which could compound the issue, such as using the phrase sole discretion, or having a different definition of cause other than that provided by the ESA and that willful misconduct standard, because that's also frequently a cause of these provisions being struck down. If the employer attempts to say you won't receive your entitlements if you are guilty of cause, and then include some other broader definitions such as insubordination, inadequate performance, those sorts of things that don't rise to that level, that can be enough as well. So turning to the next slide, Spencer. So as I noted, it's a bit of an open question. It's a hot button issue at the moment. We don't have this sort of certainty that we normally like surrounding this language. And this is exacerbated by the fact that the Ontario Court of Appeal is scheduled to hear the appeals of two of the at any time cases we've just gone over today. And this was initially scheduled to have already happened on January 16th of this year. The Ontario Court of Appeal has now adjourned those appeals to March 25th, 2026. And they've also noted that these two matters, Levy versus Wayfair and Baker v. Van Dolders, they're going to be heard alongside a third as yet undisclosed matter. So the hope is that the Court of Appeal will settle the issue of whether including the wording that an employee's employment can be terminated at any time is fatal to the enforceability of a termination clause. But that sort of remains to be seen until the Ontario Court of Appeal until we reach this March 25th date, and the Ontario Court of Appeal then subsequently releases their decision. So suffice it to say, we're probably still some time out from getting some clarity, and so it's worth at this point just taking a look at those contracts and ensuring that if we do have at any time language, what that contract looks like. And then moving ahead to a few other cases, not dealing with termination provisions specifically. The first, or these cases involve employer liability for failing to provide termination-related entitlements. And so if you can just move ahead to the next slide, please, Spencer. So even when the termination clause in an employment agreement is enforceable, or ostensibly enforceable at least, an employer may nonetheless repudiate the contract by failing to provide amounts pursuant to the employment agreement. And we saw last year in this case, Timmins, the employment agreement provided that the plaintiff would be entitled to the greater of ESA entitlements, or 3 months notice or pay in lieu of notice. And on termination, the employer only paid this employee 1 week's pay instead of the 3 months to which he was contractually entitled. And the termination letter further set out that they were withholding the balance of the severance unless he signed a full and final release, which was not included in the employment contract as a term. And so in this case, the court concluded that the employer had repudiated the employment agreement, and therefore they could not rely on the termination clause, as they had shown a desire not to be bound by the strict terms of that employment agreement. So instead of the 3 months that the employer would have had to pay under the employment agreement, he was entitled to 9 months damages at common law. And just flipping to the next slide. So just going over this case briefly, it involves the issue of punitive damages arising from delayed payments. In this case, the employee, Mr. Carroll, worked as a global strategic client executive, and he earned 180,000 base pay and a significant commission. For example, in the years leading up to termination, he frequently made over $700,000 with the base pay and the commission accounted for. The court found that this character of employment gravitated towards a longer notice period. It's obviously hard to find a position that is going to give you that sort of reward and compensation. This employee had 3 years and 7 months service. And the court found that the short notice actually tended to lengthen the notice period beyond the 1 month per year general guidepost. And this employee was also an older employee, age 61, which meant that it may have been harder for him to find a new position following termination. But what's really interesting about this specific judgment is that the court awarded punitive damages, and they found that these punitive damages were appropriate due to the employer's failure to pay him his commissions during the statutory notice period, as required by the ESA, and then delaying those payments for 8 months without any explanation that withstood scrutiny of the court. So what this is to highlight is, and punitive damages, when I refer to those, it's damages that are intended to punish the defendant's behavior and deter similar misconduct. And the bar for attracting punitive damages is quite high. It has to be something that's malicious, oppressive, and high-handed that offends the court's sense of decency. And so they're only typically awarded in exceptional cases, but the court found in this case that because they had violated his ESA rights to full compensation during the statutory notice period, and then attempted to delay paying those once they realized that they were in breach of the ESA, was enough to attract those punitive damages. And they were effectively trying to leverage a settlement with him by withholding statutory entitlements. And with that said, that wraps up the notable cases from this year, or from this past year, sorry, and we'll move ahead to talking about some topic, generative AI in Canadian workplaces. I'll turn it over to Evan to sort of get us going on that last topic.
Yeah, so lots of cases and some nuanced law, but the important piece there is nuanced law that has big impact on you as employers, because as for the reasons Ryan outlined, that termination language is one of those pieces that can cost you a lot of money or can save you a lot of money. And there's lots of opportunities where I'm reviewing termination clauses, engaging either at the time of termination or after, and there's issues with those clauses, and employers go, oh, wow, my exposure went from this to much larger. So it's one of those pieces we got to be really focused on. So when we look ahead, we think forward in 2026, some of the things that we are thinking about as a workplace and guiding, of course, our clients, a biggie is AI. And I think we're all attuned to that. Spencer, if you can jump to the next slide. But from the perspective of risk management, of course, we all view AI as a significant tool that we can use to hopefully improve our productivity, to allow our employees to be more successful in their positions. But there's also risk for us as employers that flow from the improper use of AI. So when we think about that usage, it's important to flag this notion of shadow AI, which has arisen more and more in 2025, and I foresee this happening in 2026, where you have your full-time employees or part-time, whatever it may be, using unapproved AI tools, right? Putting the question in the classic chat GPT and then relying on that information, which, if it's not accurate, of course, exposes the organization to liability. Of course, the obvious example is if you emailed me and Ryan, you would not like it if we were basing our sole legal answer on what chat GPT told us. And so flip it into your own organization. There is some liability that can flow if there's inappropriate use of AI. Let's go to the next slide, Spencer, and I'll keep talking about this issue a bit more as we wrap up. But I think we want to turn our minds to, as employers, about how do we mitigate this risk? Number one is having very clear policies on permitted use of AI. How can we use that as employees? When can we use it? What are the guardrails around usage? And that, of course, is going to very much depend on your specific organization and what work you're actually performing. But you need to turn your mind to that, in my view, on the front end versus 8 months from now calling me and saying, hey, we had this employee who was using ChatGPT and messed up all these reports, and now we're being sued by a customer. Can we fire the employee? And now, of course, my question to you is going to be, well, what did you tell the employee? Were they allowed to use it? Did we give any training to the employee? What was the expectations? And if the answer to that is we've done nothing, of course, you can expect our termination position is going to be weak. So policies, an approved use of the AI tools, and then of course, whenever we have policies, training is particularly important around that guidance. And when I think of guardrails, I think of confidentiality, right? What information are we allowing our staff to input? How are we vetting the information in the ultimate report, for example, prepared by our staff? Is there a management oversight that has to happen on that usage, for example? So again, there's lots of different ways. I think we just want to turn our minds to how do we address and proactively mitigate the risks that can flow from the use of AI, especially in the short term. Like who knows where AI is going to go, and hopefully in 5 years, maybe everything I've said is irrelevant because AI is so good. But I think in the short to midterm, we want to turn our minds to usage. Let's go to the next slide. And so some other things to think about in 2026, and sorry, Spencer, if you can jump to the next one as well as we wrap up in our last little bit. We've talked about AI and usage in the workplace. That's only going to increase. Hopefully those tools continue to increase and all of the projections are right and AI will be amazing. But in the short term, we got to turn our minds to that. Termination clauses is going to always be an issue. There will never be a time, unless the government mandates that people only get ESA, which will never happen, that termination clause is not an issue. And so you as an employer, that is your best defense to mitigate risk. You must have your team, H2R team, your legal team, regularly review and update your clauses. What was enforceable in 2024 is not in 2025, and what worked in 2025 probably will not work in 2026. So for the half hour of legal costs, you should have your clauses reviewed every single year, from my view. That's a 2026 problem, and that will be a 2027 problem. It will always be an issue. And then in terms of return to work mandates, we see that it's amazing how that's still kind of an issue. And I think it's coming to a head more and more. More and more employers in 2025 reached out to us and said, hey, we want to force people back. Like we've been doing the 2 days, we've been doing the 3 days. Now we want to go 5 days. And so that's going to be a bigger issue. And for some employers who have done nothing since the COVID times and employees that have just been off working remotely, it'll be a bigger issue. And so to the extent you're in that seat of thinking about making some return to work mandates, best to get ahead of it and provide lots of notice. And again, work with your teams to make sure it's a smooth change because it's quite a drastic change for a lot of employees. So that's a big one I think we'll see in 2026. And I suspect we'll also see some more cases. So we had some litigation with which Ryan and I are involved a lot in over the last couple of years as people have been returned back and people have been challenging return to work mandates. And those cases take years to often work through the courts. So I think in 2026, we'll start seeing some decisions, which will come out around, well, can we force? What does that look like? What's the best practices? So I think you'll hear from us a bit more in 2026 in terms of strategies and that we see flowing from the case law. The pay transparency legislation that came out, I think that trend will continue because it is I think something that a lot of workers view positively. So we have pay transparency in terms of job postings. We'll probably have more transparency legislation be issued province by province in terms of making sure employees can discuss and disclose their compensation. And the other piece on transparency, which is somewhat got some attention in 2025, kind of died off a bit is the use of confidentiality agreements in terms of settlements. And so we saw some talk around how confidentiality agreements flowing out of allegations of harassment, for example, and sexual harassment should be prohibited and should be allowed to be used by employers. Again, that kind of got a little bit of traction. It kind of has died off in recent months. But I think that may be something that will resurface in 2026, which could have a pretty drastic impact on resolutions because usually employers are often willing to pay some money because of that confidentiality piece. So again, something for us to be very mindful of if that is working its way through any legislation. So we'll pause there. Want to make sure we save some time. I know we gave you lots of information on legislation, lots of information in terms of some nuanced case law, and some things to think about in 2026. Happy to engage any questions that any of the audience may have. Also happy to answer any questions via email following the presentation.
I don't see any questions coming through, but I had one when you were reviewing the pay transparency. You mentioned now we have to include information about a pay period and a pay date. Does that refer to pay frequency and a day, or do we have to be very specific and provide a schedule in the employment contract?
Yeah, great question. So it's really focused on frequency, right? So we're not necessarily
Okay.
providing a schedule. We're saying weekly, bi-weekly, on this day, for example, et cetera.
Okay. Sorry, yeah, that wasn't really clear because sometimes, pay period may mean something different to
Mhm.
someone else. So, thanks for clarifying that. And then I had another one within the same area. When you mention the disclosure of AI during recruitment, what does that really look like in practice from your point of view?
Really, it's as simple as if you're using AI as a screening tool, is essentially have a disclosure statement in your recruitment efforts. Simple as, we are using AI to blah, 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 whatever you're using it for. So it's not necessarily a substantive, you can't use it or there's restrictions on use. It's really a disclosure obligation.
Okay.
So simply putting into the job ad that will be used as part of the recruitment process.
Okay. Got it. That makes sense. We do have one more. Do you think the government will eventually define what constitutes a long-term illness for the new leave you were discussing earlier?
I would say probably not. I think they'll stick with the serious medical condition type definition without getting into the nuance because that's a pretty challenging thing to define, right? There's some guidance to say that it can be prolonged, there can be intervals in terms of that, but I think they'll simply defer to medical professionals as to whether it's a serious illness or not, and that's a pretty broad term. But I do think it'd just be too challenging for the legislator to get into the weeds about, what's going to meet that level of threshold. So I think unfortunately they'll have lots of deference to the medical profession in terms of whether that trigger's met or not, which I think is a bit of a challenge because we all see the notes from medical professionals who are not that in depth. And so we may get a note, or you may get a note that simply is a one-liner. This person has a serious medical condition. Boom, right? So I think it will be another piece for the HR team to really potentially push back on in terms of information.
Hmm. Yeah, excellent question. Anyone else have any questions before we break? Okay, there's one more. For mass terminations, the Ontario government noted that employers are to provide a new Employment Ontario career support information sheet to employees who are given notice as part of mass termination. Is this still the case?
To my understanding, yes, it's still live. Yep.
Okay. Okay, excellent. All right. Well, thanks everyone for your questions. Evan, thank you so much. Ryan, thank you for providing us with such useful information. We appreciate you joining, and for everyone else, hope you have a great rest of the day. Thank you so much.
Thanks, everyone.
Bye, everyone.